Rajasthan High Court matter. Ready? 5 seconds. Start. The petitioners have approached this court under Article 32 of the Constitution of India. They call in question sections 3, 4 and 10 of the Insolvency and Bankruptcy Code (Amendment Act 2020 hereinafter referred to as the impugned amendments for short stop. Section 3 of the impugned amendment amends Section 7 (1) of the Insolvency and Bankruptcy Code 2016 hereinafter referred to as the Code for Short Stop. Section 4 of the impugned amendment incorporates an additional explanation in Section 11 of the Code Stop. Section 10 of the impugned amendment inserts Section 32A in the Code Stop. A financial creditor, either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor, as may be notified by the central government, may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority when a default has occurred. Stop. For the purposes of this subsection, a default includes a default in respect of a financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. Stop. Provided that for the financial creditors referred to in clauses A and B of subsection 6A of section 21, an application for initiating corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such creditors in the same class or not less than 10% stop of the total number of such creditors in the same class, whichever is less. Stop. Provided further that for financial creditors who are allottees under a real estate project, an application for initiating corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such allottees under the same real estate project or not less than 10% stop of the total number of such allottees under the same real estate project, whichever is less. Stop. Para. Provided also that where an application for initiating the corporate insolvency resolution process against the corporate debtor has been filed by a financial creditor referred to in the first and second provisos has not been admitted by the adjudicating authority before the commencement of the Insolvency and Bankruptcy Code (Amendment Act 2020), such application shall be modified to comply with the requirements of the first or second proviso within 30 days of the commencement of the said act, failing which the application shall be deemed to be withdrawn before its admission. Stop. This special leave petition arises from the judgment of the Punjab and Haryana High Court made on April 25, 1996 in LPA number 437/96, notification under section 4(1) of the Land Acquisition Act 1984. For short, the act was published on June 1, 1976. Stop. Declaration under section 6 of the act was published on February 16, 1977. Stop. The award was passed on July 3, 1981. Stop. Thereafter, the reference also become final stop. The petitioner has challenged the notification, the declaration, and the award as illegal. It contends that the award does not come in the way of the petitioner in filing the writ petition on January 21, 1994 stop. The High Court has dismissed the writ petition on the grounds of laches stop. Sri P. Rao, learned senior counsel for the petitioner, contends that the petitioner had no knowledge of the acquisition proceedings. As soon as it came to know of the acquisition, it had challenged the validity of the acquisition proceedings, and therefore it furnishes cause of action to the petitioner's stop. Over.